Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss trademarks case relating to a famous company by name Hamdard National. You can read the case as Sadar Laboratories Private Limited versus Hamdard National Foundation India in SLP number 9494 by 2023, decided by Honorable Chief Justice of India J.B. Pardiwala and Pamadikantam Srinivasamha, 3 judges bench, which did not incline to interfere toward the decision given by the Delhi High Court. The decision given by Delhi High Court is the so-called Hamdard company, Hamdard National Foundation. The Delhi High Court has ruled in its favor and asked the other company, Sadar Laboratories, to stop or to cease and desist production and selling of Afza. So what is this problem? You have to understand, unless you go to the background, there will be some prelude for this. So unless you understand the same, it's very difficult. Brief facts of the case are, you all know that Hamdard is very famous for the production of and selling of the sharbat or the cool drink called as medicated cool drink called as Rooh Afza, ROOHFZA, Rooh Afza. So for the past so many years, this has been doing the business, and for the past 20 or 25 years, Afza, that is Sadar Laboratories, they have also been producing, but in the name of medicinal thing, very small pouches like thing they have supplied. They used to be only in the medicines, but not as cold drinks. Very recently, they also started, for the past 5 or 10 years, they have started the production of Afza in the shape of the cool drinks. Now, Hamdard company, they filed a case of infringement of the Trademarks Act, Section 124 or something. If I am correct, Section 124. They filed a case against the Sadar Laboratories that they are manufacturing this Afza, which is deceptively similar to their Rooh Afza, and the consumers are being confused and they are under the impression that both of them belong to the same group, but whereas in reality they are not. So the point is, they filed a case, filed injunction, cease and desist, all these things are routine practice. But the point is, the lower court, it has correctly assessed that there is much similarity between Afza and Rooh Afza to a consumer. Normally, the consumer will be under impression that Afza and Rooh Afza, and they are the same, and they will be confused what to buy because they are deceptively similar. No doubt, Rooh Afza is a popular brand, but Afza is also getting popularity. Definitely, deceptive similarity is there. Therefore, they have given notice for cease and desist. Against the order, they went to the High Court. High Court dismissed the lower court's order, stating that, first of all, take the accounts of the so-called Sadar Laboratories. How much so-called Afza has been sold, and what are the accounts, all these things they have asked. Against the order of the High Court, now they came to the Supreme Court. Supreme Court said, it is very clear that CJI himself said, it can't be denied that Hamdard has manufactured Rooh Afza and has a well-established reputation in India. It has a well-established reputation in India. And actually, they are Section 124 of the so-called trademarks act is correct. So division bench, please remember, when Rooh Afza and Afza, when they are similar, and definitely they are leading to an element of confusion. So ultimately, even though the division bench stated that High Court asked for the accounts, Supreme Court is of opinion that yes, it is creating confusion. So therefore, the production and selling of Dil Afza has to be stopped. Right? Now, Hamdard, whenever, so the interpretation students, please remember, whenever you think of, you hear of Hamdard Dawakhana versus in of India, 1960 case, where their product, Rooh Afza, has been brought into the essential commodities, and they said it is only cold drink and the pulp percentage should be 25. All these things you remember. If not, please go through the interpretation. So this case will be an eye opener for the interpretation students also. So please read the judgment and enrich your legal knowledge. With this, I am concluding. Thank you very much.